Lian Li recently filed 2 patent lawsuits, and it's about these patents. This one specifically is Lian Li, is about its fan connection structure. And these lawsuits have wide-reaching implications for the industry. One is against Phanteks, and the other one is against Thermaltake. Some of the impact could come to consumers, and it could be in the way of, depending on how the lawsuits go, forced innovation for manufacturers against each other to come up with more options, or it could open the floodgate to a ton of fan designs that are all modular in connection structure, similar to what we have here. And if that floodgate opens, it would drive down retail cost. The complaint that Lian Li filed specifically has to do with its UNI Fan design. And we have the patent documents open up here, and what they're showing is not just the power delivery and the fan PWM delivery, but also they're talking about the specific location of placement for the power connections on different sides of the body. So this isn't just a simple daisy chaining of fans question, where true daisy chaining just by a cable has existed for a very long time, and there's a lot of prior art to it. The case is a little more nuanced. Again, talking about things like where on the fan body the connections, are located. They could probably have patented a more rigid connection in the process. This has been through this a number of times now. Thermaltake, as an example, does its fans this way, with magnets. But the key point here is that there is a structure that, depending on which company you ask, is called a luminous fan structure, i.e. LEDs on fan, wherein the power and the RGB information can be delivered through the body of the fans, and Lian Li specifically calls out that the power delivery is on 2 opposing sides of the fan body, with LEDs centered at least on the top in 2 locations, top and bottom. So the patent makes clear claims about the sides that the power delivery connections are on, the presence and the location of the RGB LED strips, the physically adjoined nature of the fans without the presence of a cable, and makes it so that this is not simply about the concept of just daisy chaining via a set of cables, but rather a specific type or combination of daisy chaining, in addition to other claims like the presence and location of LED and power connection. So this content is uniquely positioned because it's looking at both the technical aspect of this dispute and the legal aspect. And for the legal side, we hired attorney Vincent Augusta to review the case documents and to review the patent filings to give us a more professional look at what the legal side of it means. And in his section, he'll be describing not only some specifics of the case, but also a lot of foundational knowledge on patents in general, what they're meant for, and how the lawsuits might play out in the United States for all of our viewers who might not be in the US or just don't know how it works. Vincent is an excellent communicator and he can go on camera, but we also hired a specialized patent attorney who also has no involvement in this case. Unfortunately, that particular attorney can't appear on camera. It's not uncommon, it just has to do with what their firm's rules are. So we've hired 2 different attorneys to look at this case. We'll be tackling the technical side. So we're gonna go over how each of these fans connects. It's up to the courts, obviously, to decide, or in settlement, if they are similar enough to each other to have one infringe on the other, but we can at least show how they work. So let's get started. Before that, this video is brought to you by Thermal Grizzly and the CryoSheet graphene pads. These CryoSheets are molecularly stacked in the Z-axis to encourage vertical direct thermal transfer from the IHS to the cooler. CryoSheet pads are made to be easily applicable for a thermal interface and completely avoid paste dryout because it's not paste. It makes them particularly useful for long service life systems with minimal maintenance. They come in multiple sizes for suitability on the most common laptops and desktop CPUs, and you can learn more at the Thermal Grizzly CryoSheets at the link in the description below. Foundationally, this dispute boils down to just the concepts on the table in front of me. It is, in a sense, that simple. So Lian Li is alleging that Phanteks and Thermaltake have effectively stolen its design, its patented intellectual property. And in 2019 is when all this kind of kicked off. Lian Li filed for a patent for, at the time, its then unknown UNI Fan body structure, where it's a linked, adjoined set of fans with power and RGB delivery through those fans, through the body of them. It then, in January of 2020, showed to us and other media its first prototypes for the UNI Fan design. And following that, it launched the fans in 2020 later. The prototypes were widely regarded as a major advancement in ease of installation by reducing cabling needs. You can see that in some of the comments from our 2020 coverage and from other outlets. Daisy chaining has existed, including through non-standard solutions, where standard is a cable, but this particular implementation brought Lian Li a significant amount of coverage and attention. In the time since, Phanteks has filed for a patent, and it's received one. It received its own patent in June of 2023, so 3 years almost exactly after Lian Li was granted its own patent, and Phanteks filed for its new D30 fans that launched this year. Thermaltake, meanwhile, has launched its SWAFAN X fans, which, as far as we're aware, don't have a patent. Corsair is launching a series of Corsair Link products. These use advanced daisy chaining approaches as well, and Corsair has its own patent for these. However, Corsair's solution is significantly more advanced. Corsair has microcontrollers in its fans, and they're capable of transacting actual packets of data. This means that Corsair has effectively put a small computer in a fan. If only for that reason, ignoring the fact that they have significantly more money than the other three combined, it seems unlikely to us that Lian Li makes Corsair a party to one of these lawsuits. And for some disclosures here as well, all three of these companies, not Corsair, but all three of these, so Thermaltake, Phanteks, and Lian Li, are current advertisers on our channel. So we get to cover them all equally here, because from our perspective, all that matters is that the product is good. Now we get into some interesting digging. So this was just for fun, but in the time since all this news broke, we've looked around and we've learned that Lian Li is shipping to the tune of about 130,000 units of this type of fan, the UNI fans, in the North American market per month. So fans are a gigantic market. We've heard higher estimates as well. We've had difficulty verifying those higher estimates, but the 130,000 unit per month one in North America, we are pretty confident in. The average of all the estimates we've heard, speaking mostly with manufacturers in the industry, is about 270,000 units per month globally. The reason we went digging for this information is a question of motive. Knowing the size of the market and the sales volume helps us to understand the willingness of Lian Li, Phanteks, and Thermaltake to see this all the way through to court, because there's millions of dollars per month in total addressable market for this type of product. And so any one of these companies might view risking hundreds of thousands of dollars in legal costs up to maybe low millions, depending on how far they go, in order to compete for this market segment. They might see it as worth it to make that legal expense. Speaking with others in the industry, we learned some interesting information. Fans are actually one of the most profitable segments for computer hardware, at least as compared to, say, a case or something larger like that, or something more advanced, like advanced electronics, motherboards, RAM. Typically, fan manufacturers are also cooler manufacturers, and in some cases, they're power supply or case manufacturers. Be Quiet, Thermaltake, Corsair, Phanteks, Lian Li, and Cooler Master are all obvious examples. The desire to make a good fan comes from its lower logistical costs. It doesn't take as much container space, and it costs less to ship and house. Plus its lower manufacturing cost. They also benefit from economies of scale. So if one of these companies is making the same type of fan for cases and power supplies, it's a lot easier for them to break it out into a standalone unit and still benefit from volume pricing. One off-record employee of a major manufacturer told us this, quote, "As I said before, fans are highly profitable. That profit enables high revenue, low margin business units in the same company. It's more than just making tens of millions in profits on fans. It's enabling hundreds of millions of business on things that barely make money. This can be especially important in public companies that face intense pressure to deliver high revenue numbers that make the company look bigger. Plus, fans have higher profit margins to pay to the investors." Another anonymous source told us the following, quote, "The gaming industry thinks it's hot shit, but in the global fan market, it's nothing. One of our suppliers alone makes 2.6 million fans per week. And that number is across all industries, anything that has a fan in it, including digital signage or air conditioning units." Finally, another source told us this of the manufacturer they work at. Quote, "We see about $40 million in retail fan revenue, and roughly half of that is RGB fans." Now, we can't name them for obvious reasons, but one of the manufacturers in the gaming segment, specifically in the industry we're most connected to, is moving over 2.5 million fans per year across all product segments. That includes coolers, cases, and anything else they might attach a fan to. A lot of those fans were under $1 for manufacturing cost, commonly 70 cents. So it's not just looking at the fancy high-end $30 fans, but more of everything that's made by the company. And fans, all of this establishes, are a huge business. And RGB fans especially are booming right now, probably because it's one of the most visible components in a computer. Let's look at the physical properties from a hands-on, pragmatic user perspective. So this is not to pass any type of judgment on who's right or wrong in these lawsuits, but rather just to give everyone a look at how these things work. We'll start with Lian Li, since they're the ones who started the lawsuits. Here is the set of fans. These are the UNI Fan SL 120 V2s, and to give a quick walk around of what they look like, you can see it's a fan, obviously. They've got LED strips here and here. This is actually important because it's part of the patent filing explaining these. For the other important elements, they have power here and power on the opposite side here. You can see they're pogo pins that connect to pads. This is the groove system that they describe in the patent for connecting the fans together. So if you have two fans like this, we've got pin to pad, they then socket in like this. So here's them snapping, and then that's how they link together. So this is a form of daisy chaining, but it's not the one that people typically think of with two separate cables, one for RGB and one for the fan itself. This can then be linked to another one on either side, and that's sort of what made these fans compelling to begin with. For connection, they have things like this cable. So you can see this is the pogo pin side of it, except instead of being on the fan body, it's on a cable. That allows it to terminate somewhere else. So Phanteks connects differently, and that's going to be the point that they argue over in the lawsuit, because it's a matter of how differently exactly is it, and is it sufficient enough that they are found to be not infringing, you know what, on the patent. And as you can see, it does connect in a way that is not quite the same. Now, the part that matters is whether that not quite the same is different enough that Lian Li loses its ground to accuse the product of copying or infringing upon the intellectual property. It has some LEDs on the fan body, as many fans now do. It's got the fan, of course. And then they also ship these little plastic things. If we come over here on the table, that can be mounted to the front corners of the fans and kind of clean up the look of it. But the part that really matters here is how the power is delivered. So here you can see they ship it with this sticker. So the sticker says signal input cover, and when you peel one of those off, you're left with this, which if we take off the connection pieces, there's a clearly marked in and there's a clearly marked out. Now, critically, these are on the same side of the body. And one of the things we noticed from a layperson's perspective is that Lian Li's patent talks about having connections on different sides of the fan body. So Phanteks may, if only on that point, have a defensible argument, and that's one of the things we'll talk to Vincent about later. So the way these connect, first of all, you have to be careful to not connect the pins to the wrong side. But if we take two fans like this, we have in and out next to each other, we can put them down flat, grab one of these. This is the bridge. So Phanteks actually has an external bridge that is physically separate, at least initially, from the body of the fan. If we were them, this might be our key argument. And actually, if we look at the patent documents we have open from earlier, that's going to be unit 20 up here in the image. And that number 20, we think, is probably going to be one of the crux, major fulcrum points for the whole legal battle. So let's take unit 20 here. The orientation doesn't matter. And all we would do at this point is socket it in like this to grab the fan and deliver the power. So it's going from one fan into the other through this bridge with a PCB in it. Here's the Thermaltake set of fans. These ones also have in-body connections, but they're different from Phanteks. And like Lian Li, they have them on opposing sides. So you've got pin to pad on each side. They're pogo pins once again. These use magnets to connect to each other, like that. They've got LEDs, clearly, and then they have the power connection. The way they daisy chain the fans here, actually didn't even intend to do that, is not only through the magnets, but then, like the others, they have a cable that can terminate. So that's how they work in a purely technical, literal sense. And like we said, we're not trying to judge in the sense that a literal judge will do, if it goes that far, whether there's any merit to this lawsuit. Because it is a complex issue, at least in the eyes of the law, and that's what they're going to fight over. But from a consumer standpoint, you can see where the similarities are. They connect and they all send power and RGB information through the fans and through the bodies, technically, at least at some level. And you can also see where the differences are, which is that, at least with Phanteks here, it uses a physically separate piece. And again, that's what we think they're going to be arguing over. Now, we're going to get to the claims, the basics of the claims for the suit, and then we'll go to Vince and Augusta for the more legal analysis and discussion, foundational information on it. This section was put together by our team, meaning it's a technical viewpoint of a legal filing, and after reading through everything, the simple version of the Lian Li patent is this. Lian Li's core elements and claims in the patent filing are that it's for an LED fan that can connect with at least one other LED fan for a PC specifically. It consists of a fan body, LED strips on at least two sides, to the top of the body. It has a power socket and a power connector on one side of the body. It has a second connector on the opposite side. The power is all connected, so the fan itself, as in the motor, the LED, and the daisy chain fans are all fed from a continuous power connection. The LED areas of the two bodies form a continuous illumination area. A groove on the side of the body connects with another groove to connect the fans, and the grooves are on two sides of the fan. If we look at the simple version of the Phanteks patent, it boils down to this. An LED fan connection structure consisting of multiple LED fans. It consists of a fan body, LEDs, a light guide ring encircling the blade, and PCB power delivery. The power is all connected. The fan, the LED, and the daisy chain fans are fed from a continuous power connection. The power is delivered via an external PCB that snaps to the fan body via hooks. It's not part of the fan body itself. It uses pogo pins. And the snap portion to connect fans with hooks has a slot on each side, which uses a guide groove and a positioning groove, but doesn't socket together the same way as Lian Li. Thermaltake, again, doesn't have a patent we could find for this, not that that necessarily matters here. So the legal complaint filed against each company states that they are infringing on at least Claim 1. The question that'll be argued in court is whether Phanteks' product is sufficiently different from Lian Li's product, and then for Thermaltake, the same, just from their perspective. Each will be treated individually. Lian Li's success or loss in one case does not necessarily impact the other, because the products alleged to be infringing themselves are different from each other. So Thermaltake and Phanteks are not the same. That doesn't preclude them from being too similar for patent infringement. Now we're going to cut over to our discussion with Vincent Augusta, attorney and owner of Augusta Law. Vincent previously joined us to speak of consumer rights issues regarding warranties at ASUS. His background not only includes legal practice, but also working as an English teacher before that. This makes him particularly good at explaining advanced legal concepts in a way that everyone can quickly understand. Now, Vincent's focus is in law, not computer engineering, so he'll mostly be providing commentary on the patent system at large to help our non-US audience especially understand the basics, and he'll also talk about how lawsuits like this typically work, possible outcomes, and we'll get into hypotheticals of the case from the viewpoint of each party. We spent some time familiarizing him with the basics of how the products work, so now we're going to cut over to that. We're discussing how it all works and what the facts are. We've been talking about this before shooting for a while. This is genuinely a really interesting topic because there's sort of the consumer viewpoint of it, and then there's the legal viewpoint of it.
Right.
And they're not necessarily always aligned. Let's start at the very top, because not everyone is from the US, familiar with US law, but also, even though it's in the US, probably could use some foundation here. So what is this lawsuit? And at a basic level, what is actually being disputed?
This lawsuit is a patent lawsuit. So in addition to having all of the requirements of any traditional civil suit, a patent lawsuit is going to require that you demonstrate that the defendants violated, infringed upon an existing patent. And so in order to do that, you're going to first establish the scope of that patent. And then you're going to have to establish that the defendant violated each of the limitations in the claims of the patent that you're claiming that the defendants violated. So for any lawsuit, including patent lawsuits, basically you have the opportunity for the parties to come to a settlement and resolve the conflict without a final judgment. And so for this particular complaint, they're asking for an injunction to prevent the defendants from continuing to sell and manufacture the product. And also, they're asking for damages, the profits that were made off of this product, to be given to Lian Li. If the defendants win, then they will be found to have not accrued any liability. They won't owe Lian Li money, and they won't have to stop selling and manufacturing.
In this case, in this suit specifically, what might the motives be to reach a settlement?
So the primary motivation is probably money. The cost of litigating patents is exceedingly expensive. They're specialized, they're complex, and you're looking at tens, if not hundreds of thousands of dollars in legal fees. There's also the consideration of the amount of time it takes to resolve these issues, especially publicly traded companies, and even not publicly traded companies. You're looking for certainty in moving forward. Investors are looking for certainty, and a settlement offers that. The issue is resolved. And then the final point to that, kind of in the same area, is when you bring a claim to a jury and a judge, there's a great deal of uncertainty in that outcome as well. And the settlement guarantees certainty on your own terms, or on the terms that are negotiated, as opposed to risking a judgment externally that you're really not comfortable with.
Yeah, especially because you may not know the technical capacity of the people making that judgment or that decision if you feel like it's a highly technical claim or something.
Absolutely.
So, one of the things we were talking about before the shoot was, if I were in the position of either of these companies, I would be concerned about having to explain the difference, the distinctions in the product, or the similarities, depending on which side you're on, to a jury, and then you're just hoping that any of it made any sense.
Yes, so, you would assume that your jurors are going to be lay people, that they're not going to be experts, and that you're going to have to communicate to them, that each side is going to have to communicate to them somehow, make them understand the technical elements of this, to understand the very specific distinction or similarity depending on which side you're on.
Right. The patents themselves, I feel like there are a lot of misconceptions about what patents are. So some of the ones I've read from comments in the past couple of weeks with this thing going on have been the distinction between a trade secret and a patent, where I think there's some crossover there. People don't always quite know that they're different things. So first question is, what are patents, at least in the US, intended to do? And is everything in that patent public? How is that different from a trade secret?
Yeah, so in line with Article 1, Section 8 of the Constitution, patents are designed to promote sciences and the useful arts.
Okay.
And so the way this works is that basically Congress is empowered to provide exclusive protections for someone to manufacture and sell a specific product or system. For a utility patent like this, it would be 20 years. If they publish their findings and they're on their process or system, or product, so that the scientific community or the technical community can have access to it. And so the idea is that there is a trade-off, is that by publishing your work and giving everyone access to it, you are helping to facilitate the community, you're helping to progress the sciences and technology. And in exchange for that, we provide you with 20 years where you can license the product and be able to generate royalties.
Right.
So you have utility patents as well as design patents and technically plant patents as well. The distinctions are nuanced, but in terms of the general ideas being that a utility patent is for something that has kind of a designated functionality, whereas a design patent cannot be functional.
Okay.
And plant patents are an entire other beast.
So that's the intended sort of, as it's implemented,
correct,
version of that. When filing a patent, does the USPTO look for prior art? Does it act as a gatekeeper in any way for the companies filing for patents?
They do, yes. So the patent officer will look for prior art, will examine the patent, and then they will make a determination of whether or not the patent should be issued.
Strictly from the patent process perspective, does it matter how advanced the invention is for it to apply for and be granted a patent?
Not particularly. And so the requirements for a utility patent, the kind of patent that applies to these fans, is that it needs to have utility, be useful, as the statute would say. It needs to be novel, and it needs to be non-obvious. And all three of those are particularly low bars as we would consider inventions in a common context. They also need to be of a patentable subject matter. The patent needs to be written correctly. But in terms of a patent being particularly advanced or mind-blowing, that is not a requirement for being granted a patent.
Yeah, one example I looked up earlier was the paperclip, I guess, was issued a patent when it was originally invented, as an example of something that you look at it now, and it's, I mean, how special is that? It's a piece of metal that's bent in a particular way.
Right, and I think the paperclip is an excellent example because you're looking at something that is incredibly useful. It was novel at the time, and to some extent wasn't obvious given the fact that people had not done it before.
I mean, I'm sure if you're the person who invented the paperclip and someone says, well, that's if there's an internet commenter in the 1800s or whenever it was, I didn't look up when it was filed, there's an internet commenter who's like, oh, well, that's obvious. If you're the inventor, probably your response is, well, then why didn't you invent it? But anyway, that's the patent foundation and basics here. So specifics, what needs to be true for a patent lawsuit to be successful from the perspective of the company that has filed the lawsuit? So
in order to be successful with a patent lawsuit, you first have to meet all of the criteria of any other civil lawsuit. And so your complaint has to be valid. You have to meet certain jurisdictional and venue requirements, that those things are correct. Once you move past that, the actual claims of a patent suit are for infringement. And so the first thing that you will need to do is you'll need to establish the scope of the patent. This is an issue of law that a judge will decide on what the patent actually covers. And then you will move on to making an argument, either before a judge or jury, an argument of fact, which is asserting that the defendant or the defendants infringed upon the patent as the scope dictates from the previous determination. You would need to show that each limitation of the claim was infringed upon. As in the lawsuit from Lian Li, where they say at least claim 1 was infringed, they will need to show that every limitation in claim 1 of the patent was infringed, and they need to demonstrate that by a preponderance of the evidence.
Can we give an example of one of the limitations of claim 1?
Right, so the claim 1 says an illumination fan connectable with at least one illumination fan for a computer comprising of, and then it has a detail. So is it an illumination fan? An illumination fan connectable with at least one illumination fan from a computer.
Right.
Each one of those are limitations.
Okay. How about for the defendants? What might they need to be successful in a defense?
So there's a couple of different strategies that they could employ. The first is that they could attempt to argue that the scope of the patent doesn't cover the kinds of things that they have created in their product. The second is that they could argue that regardless of scope, their product is dissimilar enough that it does not infringe upon the patent. And then beyond that, they could argue that the patent itself that Lian Li has is invalid. If you can draw a technical distinction between, and again, this is kind of the very difficulty itself with patent litigation is that things are so incredibly specific and complex. But you could make the argument that one particular part of Lian Li's patent is not novel, invalidates their patent, but that you as the defendant and your patent has solved that yours is actually novel.
Okay.
And so down the rabbit hole we go.
Yeah, right. How about from a consumer standpoint, how, if at all, how does this affect consumers currently?
So currently there won't likely be a huge impact on consumers. Normally, if you're looking for immediate impact on consumers, you would look for something like a temporary restraining order or a preliminary injunction, which, if granted, would prevent the defendants from continuing to manufacture and sell the product even before the lawsuit is resolved. So in the filing, Lian Li does not ask for a temporary restraining order or a preliminary injunction. And those are rarely granted anyways. So you would likely not see companies change the way that they are manufacturing or selling the product.
And so that leads into the next one, which is how might this affect consumers in the future?
Well, it gets additionally complicated by the fact that each of the defendants seems to have their own, well, at least some of them have their own patents as well.
Right.
But you would imagine that if Lian Li is able to establish that the defendants infringe on their patent, then likely they will not be allowed to continue to manufacture and sell a product. If they are, it will be with some sort of royalty settlement, likely, a royalty deal, which will increase the price potentially
of the competing
of the product.
products. Yeah.
And if Lian Li is unable to meet that burden, then it's possible that other competitors might enter the market. There may be people waiting on the sidelines who are waiting for the dust to settle before entering this market, and they may come in with even more affordable products, or they may just generally increase inventory now that they feel that there's a certainty to this patent issue that they don't feel like they're going to be sued.
Right, some kind of precedent. Although they'd have to navigate not then infringing on Phanteks' patent.
I mean, and it wouldn't necessarily be binding in any way. Just because Lian Li lost this lawsuit doesn't necessarily mean that they couldn't bring a lawsuit against a different defendant. But some of the arguments, some of the conclusions may have a preclusive effect. And realistically, just in kind of a general sense, you're just going to feel like, as a competitor, that you're less likely to be sued if they already lost a patent lawsuit against them.
Right, even if just strategically or from public perception or something. One of the things we talked about is on this topic of other competitors on the sidelines, they would, it's interesting because if the suit is ultimately, let's take Phanteks just to single them out from Thermaltake, but if Phanteks is found to be not infringing, that doesn't then necessarily open up sideline competitors to say, okay, this design wasn't infringing, therefore we'll do this design.
Correct, because that design is also patented.
Right, and likewise for Lian Li.
Just because there was no liability for this particular product doesn't mean that a new product would not incur liability for infringement.
Right, for different reasons, yeah. Do you have any general opinions on the filings or any specific language you want to call attention to in them?
Yeah, so I thought the filings were brief and to the point. I think as a general rule with complaints, you want to avoid over-claiming because you own the language and the claims that you make. And so one example of that is that in the complaint, they talk about how at least claim 1 has been infringed upon. So the patent has multiple claims to it, and they've articulated in their complaint that at least claim 1 has been infringed. And this language is important because it meets the minimum requirement. You have to make the assertion that at least a claim was violated, but it leaves open the potential of coming back and revisiting the other claims, but it doesn't overclaim.
It doesn't commit to that.
It doesn't commit to any other additional language, which again, in some instances could end up being trivial, but it's always important to be on the lookout for that. And as an attorney, your goal is to absolutely minimize any potential exposure that you would have to being held to a claim you didn't want to make at that time.
Right, or hurt your own argument. So if let's take this from a hypothetical standpoint. If this goes all the way through a trial and there's a ruling on it and it's not settled, let's say Lian Li is unsuccessful in bringing its claims and Phanteks and Thermaltake effectively sort of win. Are these companies have now, is it fair to say, have probably, if you've gone all the way through trial, invested like 6 figures plus into legal fees?
I think that's fair. If you take a patent lawsuit to its natural conclusion as a defendant, you're probably spending over $100,000.
Right. I would think easily in some cases too. So at this stage then, if you're hundreds of thousands or millions of dollars into legal fees and the defendants have successfully defended themselves, are they awarded any compensation for that? Do they have an avenue to sue for legal costs?
So generally, the answer is no. In our legal system, the default position is that the parties pay their own legal expenses. And there are very few situations where you're allowed to recoup legal costs and legal fees. Primarily they're by statute. If there is a particular law that explicitly says that one party or another can get attorney's fees, then you can use that.
Or I guess maybe if there's a contract dispute.
If there's a contract dispute and the parties have stipulated to certain parties getting legal fees, usually it's the prevailing party getting legal fees. And then alternatively, there's sometimes for things like frivolous lawsuits or sanctions, things that are maliciously generated, then you could potentially get legal fees.
If you were acting as an attorney, let's say for Phanteks or Thermaltake here, and they successfully defend themselves, if I'm the CEO, what would your advisory be? If I say I think this is frivolous, the lawsuit Lian Li brought against us is frivolous, how do you navigate that?
It does not appear to me that this is a frivolous lawsuit. So the standard for things that are frivolous or kind of sanctionable it's pretty high. And usually it involves kind of going so far beyond what is acceptable, and that you're doing things like not responding to discovery requests.
Okay.
If you were to misrepresent or lie about something to the judge, it has to be particularly egregious. And in terms of a frivolous lawsuit, then you'd have to be kind of bringing claims that just had no basis in law. And even then, sometimes you're not getting attorney's fees. So it's a very difficult argument to make, and it's not a particularly successful one.
Okay. On the hypotheticals again, if you were an attorney for Phanteks or Thermaltake, what considerations might you have when weighing the pros and cons of attempting to invalidate Lian Li's patent in the course of this? And is there what kind of risks are associated with making that argument?
What's interesting here is that Phanteks has their own patent of something that's at very least similar in the same space. And so arguments that you would be making, as we discussed earlier, the arguments you would be making to potentially invalidate a patent could be used against you. And so if you're arguing that this concept is not useful, if it's not novel, if it's an obvious invention, you have your own patent to worry about.
And your own product.
And your own product.
Because you might potentially say the product is useless or is inferior somehow.
Correct.
So, yeah.
And again, on the other side, if you can find a very specific part of Lian Li's product and their patent that you could argue really invalidates the entire patent, but somehow you have maintained these requirements, then you could potentially get an incredible market advantage.
Phanteks would potentially remain holder of its own valid patent.
Correct.
For different reasons, right? How about if you're an attorney for Lian Li, so now you're on the other side, what might your strongest approach be for arguing the infringement of the patent? And how do you balance the different roles that the judge or the jury play? And maybe helps to give some foundational knowledge there too, because they kind of serve different purposes in the courtroom.
So functionally, when you're talking about the scope of the patent, as the plaintiff, you're going to want the scope of your patent interpreted kind of broadly, so that you can include specifically in this case, you can include the other product that is that you're arguing is infringing.
Right.
Then when you make the infringement argument itself, you're kind of arguing the product itself falls within that scope and therefore it infringes. And so that argument is difficult to make to lay people. And so you have to find ways of approaching this and explaining this very technical similarity to someone who is not in that space.
What does the judge do in this situation as opposed to what the jury does?
So the judge will make a determination about the scope of the patent. They'll interpret the language of the patent, and the parties may argue about that. But that's an issue of law, a question of law that the judge will exclusively deal with. After that, and in this case specifically, I believe that Lian Li asked for a jury trial.
They did, yeah.
So then the jury will then be the determiners of the issues of fact.
Okay.
And that will be whether or not this specific product infringed upon the patent which now has a scope that has been determined by the judge in this case.
Okay. If you're representing Lian Li, you know, if you're seeking settlement, what kinds of settlements options might there be, as opposed to going all the way through trial, and what kind of sort of, you've won the lawsuit, what options are there at that point?
It's a difficult balancing act, but in a situation like this, royalties associated with the continued sale of the product seems like a very reasonable settlement opportunity. If you were dealing with a company that was willing to negotiate a settlement where they stopped selling the product and compensated you to some extent of the products they already sold.
That seems very unlikely.
Seems unlikely in a case like this. Sometimes you may see that if you have a very large company kind of going after a smaller company and they're obviously infringing, something like that. And then ultimately, if you have to go through the entire process, then you're looking for a judgment in your favor.
While I was doing research on trying to figure out what might be beneficial to bring into a video as educational material for the audience, it's very diplomatic in my phrasing. one of the comments I read, I just want to, I think this encapsulates a lot of the general sentiment. So the count was, I don't see this going anywhere. Lian Li can't patent the concept of daisy-chained fans, and Phanteks isn't using the same identical method. What is your general reaction for that?
So I think it's important to make the distinction that this patent is not for daisy chaining fans. This patent, and again, I'm not a technical expert, but my understanding is that this patent is for a very specific way of attaching fans, and with a specific description of how they are connected in terms of the electricity they receive, in terms of the RGB lighting, in terms of where the connectors are, how they function. And so that, to say that it's just a patent for daisy chaining fans, although that may be true that they wouldn't be able to patent just daisy chaining fans, this certainly is much more complicated. Indicative of that is the fact that they were successful in getting the patent, right?
Yes, it was granted.
Yeah, so
actually two companies were granted.
Correct,
yeah.
in two different ways, two that we know of. And so, and then in terms of the differences between Phanteks fans and Lian Li, is that even if literally the fans are different, the question is, are they sufficiently different to not infringe upon the patent? They really need to be exceedingly similar, almost exact, in order for it to be infringement. However, that conversation is incredibly nuanced.
And that's what we basically need to let play out at this point.
And that's what the parties will be fighting over.
Right.
Yes.
We've talked about some of the potential negatives for consumers when one party wins versus another. But let's just talk about, generally speaking, regardless of who wins or loses here, what might be the positive outcomes for sort of the PC building market or for the consumer? Well,
whenever this lawsuit is resolved, hopefully it'll bring some clarity and some predictability to this particular market. And so companies, generally investors, consumers, are going to favor some sort of coherence in the market, some sort of consistency and stability, where they know if they manufacture a product, if they invest in a product, if they purchase a product, then that product will not be the subject of lawsuits and disputes, that there won't be massive fluctuations in inventory, of price, availability.
RMA options as an example.
Correct.
If one were to disappear overnight.
Absolutely, yeah. And so I think that resolution of these kinds of disputes can provide that in these types of spaces. Not necessarily, but it is definitely something that can happen when you resolve a dispute of this nature.
Right. Last question is, which angry commenter were you on Reddit when you were commenting about this?
I have made no comments about it, quite frankly, because I think it's an incredibly interesting and nuanced discussion.
Yeah.
And so
it deserves a little more than.
Yeah, I don't have an ultimate conclusion in my mind as to the resolution of this. You know, it's a very difficult area of law.
Yeah. Also, good luck to all the parties, I guess, in resolving this. But thank you, Vincent, for joining.
Thank you, Steve. Appreciate it.
And we'll cut back to the rest of the video. So that's it for this one. It's a really interesting case. It's fun to do this kind of stuff. You can go over to patreon.com/gamersnexus. That helps us recoup some costs anyway, because we do, in fact, pay Vincent to assist with this because it involves a lot of work. He had to read the documents, read the patents, and come in with an informed opinion. So hopefully you found that interesting. We're going to be following this as it develops. Legal cases can be really slow. It depends on if they move to a settlement or if they're going to proceed all the way through the legal system. So, and at each stage that could change. But we'll keep covering it. Let us know what you think below in terms of your perspective on if the products seem different enough or not. I'm sure the judge and the jury will carefully read through the comment section and base their opinions on that. But otherwise, thanks for watching. Subscribe for more. Go to patreon.com/gamersnexus, and we'll see you all next time.